so should be joining us momentarily.
Yep, no problem. How's everybody else today?
Doing very well, thank you.
I've done well.
All right, Mr. Chair, Ms. Stiegelmeyer has joined us.
Yep. All right. So my name is Quint Redmond, Matthew Redmond, actually. And I'm calling the June meeting for the Mineland Reclamation Board meeting to order Wednesday, June 18th, 2025. Do I need to call the roll?
Yeah.
Yes. Mr. Oren not here. Ms. Stiegelmeyer online.
Present.
Ms. Wareham.
Present.
Ms. Nelson. Not here. Mr. Baker.
Here.
I'm here, and Mr. Malk.
Nope.
Not here. All right. Very good. All right. So the first order of business is approval of the May 2025 summary of minutes. Anybody have any comments? Can I get a motion to approve the minutes?
I motion we approve the minutes.
Second.
Mr. Baker, second by Ms. Wareham. All in favor?
Aye.
Aye.
Aye. Any against? Hearing none, the minutes are approved. And Chuck, or I'm going to send these. I'm going to sign them digitally and then send them. Who do I send them to? Cami or you, Chuck?
Yeah, Cami.
Okay. All right. Very good. All right. Continuances and withdrawals. The paperwork I got says we don't have any of those. Is that correct?
That is correct.
All right. Very good. All right. Mr. Malk is not with us. So is there someone to give that report, or are we going to skip that for the meeting?
I believe we'll be skipping that today, Mr. Chair.
Awesome. All right. Mr. Cunningham, care to?
All right, thank you, Mr. Chair. Good morning, members of the board. Michael Cunningham with the Division Director's Report. I just want to let the board know that next week, DRMS staff will be attending the Interstate Mining Compact Commission. This is the annual meeting that'll be hosted in Gillette, Wyoming. As a reminder, with the passage of Senate Bill 2554, we are now a full member of the compact. And as such, we will have the ability to vote on matters and to serve on various compact committees. So we're eager to get up there and participate next week. I'll be attending along with Jason Music, the Coal Program Director, and Jeff Graves, the Inactive Mines Reclamation Program Director. We have a lot of business to discuss, and we'll certainly share anything that comes out of that with the board at next month's hearing. We'd also like to let the board know in terms of Schwarzwälder Mine, we have commenced water treatment operations on May 6th. And so things are moving along up there. We will likely treat water through October again this year. And again, our focus remains on treating water at this time. Just a quick note on rulemaking. Now that we have approval of Senate Bill 2554, staff has been working very hard on red line edits. We have a discussion item later this morning, so I'll let Russ share with the board some of the details of our stakeholding meetings that we have scheduled here over the next few weeks. And the last thing I just want to note for the board has to do with some training that we've recently facilitated. As the board may or may not be aware, we go to a lot of training that is facilitated by the Office of Surface Mining Reclamation and Enforcement. They receive funding from the federal government to host training for states. The training covers a wide variety of topics that are pertinent to the work that we do, principles of inspection, hydrology courses, soils and re-veg, geochemistry. These are really incredible and invaluable classes that we rely on. We send a lot of our new folks to them. Pretty much all of our environmental protection specialists that work at the division have gone through a series of these courses. As folks know, with a lot of the changes with our federal partners, they've been impacted in a variety of different ways. OSMRE has recently gone through a fairly large staffing reduction. And as such, they were not able to provide those trainings to the states this year, which of course was disappointing as we rely on those heavily. But we have a number of staff members who are certified course instructors through the Office of Surface Mining Reclamation and Enforcement. So our staff signs up for courses, and when they're selected, they would, in that situation, go to a different city wherever this is being hosted. OSMRE facilitates the organization. We show up and we lead the instruction of these courses. So we thought, we've got the staff, we've got the knowledge, the expertise, and the ability to put on these trainings in lieu of the federal government. And so we decided to step up. And just last week, we hosted a soils and re-veg course. We did open that up to other states who also had an interest in a need for these trainings. And I'm pleased to say we had a really successful training. We had staff in attendance from Illinois, New Mexico, Utah, and Wyoming. This training was put on by Jared Ebert, one of our senior environmental protection specialists in the Active Mines program. He did that in conjunction with Brock Bowles, who is our senior EPS3 and staff expert in vegetation and noxious weeds. So it was great. I think it was well received. We'll be looking to potentially host additional trainings throughout this year with the hope that in calendar year 2026, the federal government will be able to resume those trainings that they've historically provided to the states. So kudos to Brock and to Jared. And that concludes the director's report. I'm happy to answer any questions from the board if there are any.
That's very cool. So do all the states have the ability to teach the courses, or is that something that we have done just to sort of be ahead of the game and on top of it?
Yeah, that's a great question. Many of the other states also have instructors. I couldn't quite speak to the number, but certainly with our staff, we've encouraged them, some of our more senior staff, to go through that instructor course training. We've got a lot of knowledge. We also think it's important to have sort of a Western perspective in these trainings. Oftentimes, because this is through the Office of Surface Mining, Reclamation, and Enforcement, there's a focus on coal. As we know, a lot of the coal activity is centered in the eastern part of the United States. But there's some pretty key differences in terms of reclaiming a mine site in the west as opposed to the east. Revegetation happens to be one of those pretty big differences. When we've attended courses out east and looked at a revegetation project that might have been completed 1 year prior, we go out, we typically see grasses that are waist high, nice and thick. Obviously, they've got different climatic conditions that they can deal with. We often inform our eastern counterparts that in Colorado, typically a minimum of 2 to 5 growing seasons before we see adequate vegetation out there.
Yeah, they don't know what a blowout is back east. They just never heard of that.
That's exactly right.
Yeah. So where do you hold that? Do you have them in the field, or do you have is there a combination of office training and field work when you do that?
In a standard course, yeah, all of the attendees will go to a city. There's a classroom component, so it's usually in a conference room in a hotel. But then there is also field trips that are scheduled throughout that week or however many days of training we have. So yeah, getting out in the field is incredibly important to have that hands-on component. For the training that we hosted, it was all virtual. Other states, are not always in the position to dedicate funds to sending folks to these trainings. In a normal situation, the Office of Surface Mining Reclamation and Enforcement would cover our travel expenses. So for this particular training, it was virtual, and that's how we handled that one.
Yeah, very good. Well, thank you very much. It's really great to be leaders in that arena. Does anybody else have any questions for Mr. Cunningham? Very good. All right. So the consent agenda is next. Does anybody have any questions, or can I get a motion to approve the consent agenda, file number M 1986-123?
So moved.
Hey, that's consent agenda is approved. Do we need to vote on that? I guess we need to vote on that.
I
So-
second.
You, all right, motion by Wareham, second by Stiglmeyer, and can I get a vote? All those in favor? Aye.
Aye.
Any against? Not hearing any. The consent agenda passes. All right. Number 5, enforcement hearing, file number M-1991-054. Indian Creek Mining Corp. I'm not sure who the staff person is, but
I am.
oh, very
Todd
good.
Jesse.
Very good. Take her away, sir.
All right. Let me just share a screen really fast. Is everyone able to hear me right now?
Actually, do I need to do a swear in?
Sure, yeah.
Is everybody involved in this case promise to tell the truth?
I do.
I do. Thank you. Go ahead, Mr. Jesse.
All right. Hopefully everyone's able to see my screen. All right. Good morning. My name's Todd Jesse. I'm an environmental protection specialist in the Grand Junction Field Office. The matter before you today involves the Prophet Mine. The Prophet is a 110-1 limited impact operation in Saguache County. It's operated by Indian Creek Mining Corporation and is a gold-silver mine with a permit area of 1.9 acres and a bond of $1,500. The reason for the hearing today is consideration of financial warranty forfeiture for failure to comply with Board Order MV 2024-021, which required the operator to submit the past due 2024 annual report, map, and fee. And this is the final hearing in the process. A brief timeline of events involving the matter. May 29th, 2024 was the anniversary date for submitting the annual report, map, and fee for this permit, and no submittal was received. On July 9th, 2024, DRMS sent a reason to believe letter and notice of board hearing, civil penalties, and cease and desist order for failing to submit the required 2024 annual report, map, and fee. That reason to believe letter and notice of hearing was returned to sender on August 23rd, 2024. Then during the September 18th, 2024 Mineland Reclamation Board hearing, the board found a violation for failing to submit the annual report, map, and fee for this permit, and the board assessed a civil penalty in the amount of $172. October 18th, 2024 was the deadline for board ordered corrective actions, and corrective actions were not completed. On November 19th, 2024, DRMS sent the November 2024 findings of facts, conclusions of law, and order for Board Order MV 2024-021. On January 9th, 2025, DRMS sent a reason to believe letter and notice of hearing for failure to comply with Board Order MV 2024-021, which required the operator to submit the past due 2024 annual report, map, and fee, and pay the civil penalty. During the February 19th, 2025 Mineland Reclamation Board hearing, the board ordered that permit number M1991-054 be revoked. The board found that the financial warranty for permit number M1991-054 in the amount of $1,500 is subject to forfeiture in accordance with section 34-32-118, parent 1, parent B. The board affirmed the cease and desist order. The board assessed a civil penalty in the amount of $6,200, which combined with the $172 in civil penalties assessed in the board's November order for violation M 2024-021 reflects a total civil penalty of $6,372. On April 8th, 2025, DRMS sent the February 2025 findings of facts, conclusion of law, and order for Board Order MV 2024-021. On May 5th, 2025, DRMS sent a notice of hearing for forfeiture of financial warranty to the operator and financial institution. And May 8th was the deadline for the board ordered civil penalties, and civil penalties were not paid. So the legal basis for permit revocation and forfeiture of financial warranty. In the board order sent on April 8th, 2025, the board found the financial warranty for permit number M1991-054 to be subject to forfeiture under CRS 34-32-118, parent 1, parent B, for the operator's failure to cure a default under its performance warranty. Pursuant to CRS 34-32-118, parent 2, when the board has reason to believe a financial warranty is subject to forfeiture, the board shall so notify the operator and all financial warrantors. The board shall afford the operator and all financial warrantors the right to appear before the board at a hearing to be held not less than 30 days after the party's receipt of such notice. Pursuant to CRS 34-32-118, parent 3, parent A, at a hearing held pursuant to CRS 34-32-118, parent 2, the board may withdraw or modify any determination that the financial warranty is subject to forfeiture, settle of compromise the determination, or confirm its determination that the financial warranty should be forfeited. The division did send on May 5th, 2025, DRMS did mail the required notifications of board hearing for forfeiture of financial warranty to the operator and all financial warrantors pursuant to CRS 34-32-118, parent 2. So staff recommends that the board confirm the determination that the financial warranty should be forfeited in accordance with CRS 34-32-118, parent 3, parent A, and issue a written finding of fact and conclusion of law to support its decision, and issue an order directing affected financial warrantors to immediately deliver to the board all amounts warranted by applicable financial warranties in accordance with CRS 34-32-118, parent 3, parent B. Thank you for your time. I'm happy to answer any questions.
All right. Does anybody on the board have questions for Mr. Jesse? Are there other staff contributions, or I'm assuming the operator's not in the room there or online?
No, we haven't had contact with the operator in over a year now. All of our attempts to reach out to them were unsuccessful. My latest attempt was on Monday.
Okay. All right. Nobody has any comments. Is there a motion to move for the staff recommendations?
I motion to approve the recommendations of the staff.
Is there a second?
Second.
All right. Any further discussion? Hearing none, let's take a vote. All in favor of the motion, say aye.
Aye.
Aye. Any opposed? Hearing none, the staff recommendations pass. The motion passes. Thank you, Mr. Jesse.
Thank you.
All right. Very good. So moving on to number 6, discussion item. Mr. Cunningham, you have the floor.
All right. Thank you, Mr. Chair. Thank you, members of the board. My name is Michael Cunningham, and I'm going to be just discussing the Office of the State Auditor's findings and recommendations from the performance audit of the Mine Subsidence Protection Program. Today, we also have several staff members from the Office of State Auditor joining us, Heidi Wagner and Trey Stanley. I will let them introduce themselves, but I think for today, what we'll do is I will let them start off and just give the board a reminder, a little bit of background on how this process started, some of the work that we did over the last year, culminating with the hearing before the Legislative Audit Committee this past Monday. In the board packet, you should have a copy of the Mine Subsidence Protection Program Performance Audit dated May 2025. After the Office of State Auditor staff gives their intro and comments, I'm going to walk the board through some of their findings, recommendations, and we can discuss how we intend to implement the 7 findings within the report. So with that, I will turn it over to Heidi.
Thank you, Mr. Cunningham, and thank you, board, for letting me come here today. I am Heidi Wagner with the Office of the State Auditor, and I was the supervisor on this project. And also with me is Trey Stanley, who is the manager on the project. So I just am going to give a brief rundown of how the audit started and how it went, and then I'll turn it back over to Mr. Cunningham. So the basis for this performance audit was a legislative request. In 2024, Representative Puglisi requested a performance audit of the mine subsidence protection program, specifically that program. And the Legislative Audit Committee voted to approve the audit around July last year. The committee includes 4 representatives and 4 senators, and it's equal representation of the 2 major political parties. Performance audits provide an in-depth look at operations, and they use objective criteria. And performance audits often identify opportunities for process change. So with this audit, we engaged the Division of Reclamation, Mining, and Safety, and we started our audit about September of 2024. The audit plan we developed include 4 focus areas for our fieldwork: to evaluate the claims process, evaluate the program structure as a trust rather than an insurance program, to look at program budgeting, and we also evaluated some options of different programs from around the country, other mine subsidence programs. We also looked at those options and how different programs were structured. We, worked really closely and collaboratively with the division, and their staff was helpful and informative, and they provided us all the data we requested and any sort of documentation, and we evaluated it all. That they provided. We had a sample of claims that we tested against criteria, and we also interviewed the program staff and program management to understand how the program was operating. We developed recommendations for the division based on the results of this fieldwork. We presented those to the division, and Mr. Cunningham is going to cover in more detail what we found. The division agreed with the recommended improvements, and provided responses explaining how they plan to implement the recommendations. And then those are included in the public report. So on Monday, the Legislative Audit Committee meeting, they voted to release our report to the public. And our audit team presented the background information on the program, and then also presented 2 recommendations. So at that point, division staff and Executive Director Gibbs presented their responses to the recommendations to the Legislative Audit Committee members, and also answered any questions the members had about the program. And so that's kind of the rundown of the update on the audit. So I'll turn it back over to Mr. Cunningham.
And thank you, Heidi. Before I move forward, any questions for Heidi or OSA staff before I move on? Okay, hearing none, I'll move forward. Thank you, Heidi, for that introduction. And again, I just want to thank OSA staff for their thoughtful approach in working with us. It was very collaborative. We appreciated their recommendations. And with that, I'm going to jump into this report. And as I move through this, please, if you have any questions, just let me know. I'm happy to answer those as we move through this. I'm going to start on page 7 of the report with finding 1, which focused on program administration. And so I'll read certain excerpts out of this report as a reminder for the board. The program, which began operations in 1989, was initially administered by a contractor. That contractor served as the plant administrator from the program's inception all the way through 2012. In the following year, 2013, the board moved the administration within the division, and since that time, the program has been administered by division staff. At around that same time, we also entered into a memorandum of understanding with the Office of Surface Mining Reclamation and Enforcement. The grant and the MOU established the conditions under which the state must administer the program. It also included a plan of operations that provided specific operational requirements. So overall, the state auditor found that the program did have consistent practices for reviewing claims, found that we were substantially following program rules. However, the auditors also found that the division had not complied with all of the requirements or ensured that its federal agreement and program rules remain current and reflect the controls it intends to use for the program. So I'll speak a little bit more about what some of those deviations are. Starting with the Memorandum of Understanding with the Office of Surface Mining Reclamation and Enforcement. When we first entered into this Memorandum of Understanding, it was valid for a 10-year period, at which point it was to be taken a look at again, updated, re-signed, and it did have an automatic expiration at the end of that 10-year period. And so the auditors brought to our attention that we had been operating under an expired MOU since that time. The MOU, this likely occurred due to some of the change in how the program was administered. The third party who was administering this program outside of the division would have had the responsibility for updating that MOU with our federal partner at that time. It didn't happen, and then when the administration shifted back to division staff, we missed that, and we did not move forward with that either. So we do have some work to do there on that MOU, and I'll talk a little bit more about that here in a second. The auditor also found that in practice, we're following many of the elements of the plan of operation that was established under that MOU. However, there are several key requirements that we're no longer following. A few examples of those are in 2002, the board amended program rules for the program to offset the cost of initial inspection, and the program now covers almost the entire cost of that. Additionally, the plan of operations set the maximum benefit that participants can receive for each mine subsidence occurrence at $50,000. This is different than the program rules, which now allow for up to $100,000 per occurrence. Now, we are allowed to make changes to our plans of operation without prior consent from the Office of Surface Mining Reclamation and Enforcement, but we are also must promptly furnish a copy of each such amendment to the Office of Surface Mining Reclamation and Enforcement. And we had not done that for some of the rule changes that the board had implemented to bring that back in line with the plan of operations. So some other areas where our practices weren't currently aligned, according to program rules, we are to provide periodic reports to the board and to the Office of Surface Mining Reclamation and Enforcement, showing all receipts and disbursements during the period and assets then held in the trust. So we've had some discussions with the board on this. We did have our first meeting of the year to discuss some of these elements of the program at our April hearing. And we'll be having some additional conversations with the board to just see what is going to work for the board in terms of having these routine meetings throughout the year and how frequently we're providing reports. And so we're going to continue that conversation with the board. Another area where we weren't consistent is under Program Rule 8.04.2, which states that homeowners aggrieved by a denial may petition the board for review of the termination within 30 days of the denial. In practice, the program administrator typically resolves disputes on claim decisions and may authorize the division's contractor to perform additional testing when a dispute arises. So this practice that we've adopted is not currently provided for in program rules. And then lastly, another area of inconsistency is that homeowners are required to file a claim within 90 days of the subsidence event. Again, in practice, we've not been requesting documentation of the date that subsidence event occurred, as it can be a challenge to identify exactly when that happens, as a lot of this damage can manifest itself slowly over time. And it makes it difficult for homeowners to be able to confirm the date that the event occurred. So we have built in a little bit of leeway into that process, and we're going to need to address that. Obviously, these issues matter. They're important. With respect to the MOU, there is a risk that we've been operating this program outside of our authority, And there is the potential for, adverse actions from our federal partner who provided this initial grant to set up the program. We have been in discussions with the Office of Surface Mining Reclamation and Enforcement. They have indicated they don't have any concerns about currently where we're at or how we've been administering the program, but we will be working with them to update our MOU as well as the plan of operations. Additionally, when our practices are not aligned with our rules, this can create confusion, not just among staff, but with the public, with the board. And we want to ensure that we are consistently administering this program. And so that's an area that we need to work on. And again, not having those written policies and procedures can create a risk, that we will not be consistent over time. And so we want to ensure that we do the work to make sure that we can remain consistent. And so with that, I'm moving on to page 12, and I'll cover the 3 recommendations that came under this first part of the evaluation. The first recommendation is working with the Federal Office of Surface Mining Reclamation and Enforcement to renew our memorandum of understanding. This would include updating the MOU's plan of operations to ensure it aligns with program rules and practices. So as I just noted, we have been communicating with the Office of Surface Mining Reclamation and Enforcement. They are currently having conversations with their solicitor, but we have agreed on this recommendation, and we've set an implementation date for December 2025. So that's one of our near-term goals that we need to accomplish, and we're pretty confident that we'll be able to do that before we get to the end of the year. As soon as that is signed and in place, we will update the board on that. The second recommendation was to perform a review of program rules to ensure that they align with current practices, and working with the Mineland Reclamation Board to update our program rules as needed. So for Part B, we will initiate a comparative analysis of current practices and existing program rules to identify any areas of inconsistency. This will be an exercise that our staff will undertake, and we will have this particular recommendation completed by June of next year. The third and final part of this recommendation deals with performing a review of program rules to ensure that they align with current, I was reading Part B. Part C, establishing written operational procedures for the program. So as the state auditor found, we do not have clear written procedures or policy or guidance documents in place for our staff. As the board knows, we did have a change in that staff position. Deb Zach, who is here in the board today, is our new program administrator. So this does provide really a good opportunity when we go through the staff transition to document all of our current practices and policies. Part C really will inform Part B. Both of these, you'll note that the implementation date is the same. So we'll be working on these concurrently. We think it's going to be beneficial to have our standard operating procedures, guidance, and policy documents in place. That way we can see where we're out of alignment, and then that will inform, what work we need to do with the board on updating any program rules. And so I'm just going to take a pause there and see if the board has any questions on any of those recommendations or our responses to them.
So I have just one question, and I'm a little confused, but I think you said something about the program was originally administered by a contractor, but that is no longer the case now. It's going to be administered internally.
Correct.
Okay.
That is correct. Yeah.
Yeah.
The first 10 or so years of the program was
Right.
administered externally.
Got it.
Any other questions? If not, I'll continue on page 13 to the second finding of the report. So the second finding centered around program structure and performance. And so I'll note that with the grant that we received, states were able to set their, they had a lot of latitude in establishing these programs. We have the discretion on how to set our own eligibility requirements, fees and premium rates, coverage limits, as well as choosing who administers the program. So, the examples there are a state agency, private insurer, or a state contractor, as we were using at the inception of this program. When we received this grant, we did a lot of investigation and analysis into the current state of affairs at that time in the late 80s. We hired a consultant to take a look at available information on mines. We commissioned studies on the risk of mine subsidence, the number of homes potentially impacted, and the viability of the potential market for covering homes through commercial insurance policies. And using that information, we came to the conclusion that the potential pool of participants was too small to form a viable insurance market for Colorado. Additionally, private insurers at the time were not interested in providing mine subsidence insurance. And so for these reasons, we structured our program as a state-owned trust rather than insurance. As the state auditors took a look at this program administration, they measured the program's performance by reviewing participation rates, the number of claims received and approved, and the amount of claims paid over the program's history. Largely, they determined the program's current structure as a state-owned trust rather than a licensed insurance program complies with applicable state and federal law. And so we were operating within the discretion that we were given through the federal government, through our own state statutes to set up this program. Here in a little bit, I'll talk about how that structure potentially could change based on the recommendations that we will be following here. Additionally, the auditors found that the program participation is relatively low. Few mine subsidence claims are paid, and the program administrative costs are high in comparison to the benefits the program provides, and those costs have risen in recent years. So of the 861 homes that are eligible, about 14% were enrolled in our program as of July of last year. The participation rates appear to have decreased over time. And then according to our records, we had 1,074 homes enrolled in the program in 1996. So clearly we do have a decrease in participation over time. It is something that we want to look at and try to understand why that is. One of our internal goals for the program is to increase participation, to increase awareness amongst the public of this program and let folks know that it's out there, that it's valuable, and that they can participate in that. And we have done outreach efforts in the past. I think we've discussed this with the board. The last outreach effort that we conducted was in 2022 when we sent out mailers to all of the homes that were eligible for the program, but were not currently participating. We did have a minor uptick in participation following that public outreach. But I think there's certainly opportunity to consider other options for that. We're having discussions on that during our Legislative Audit Committee hearing on Monday. Representative Wilford did have a comment for division that she would like to see us focus our more on our marketing efforts. And we certainly agree with that comment and are gonna continue to brainstorm ways that we can increase awareness of this program. With respect to the decline in claims being paid, since the start of the program in 1989, the division has paid a total of $1,036,500 for mine subsidence claims at a total of 19 houses. This is reflected in the Exhibit 3 on page 17 of that report. You can see the different payouts over time from this program. The auditor also found that the program denies most claims and has approved a smaller proportion of claims in recent years. Specifically in reviewing the program data from calendar year 2010, that was the earliest year for which program had maintained the relevant data. Through 2024, they found that participants filed 128 claims, of which 18 or approximately 14% were approved and paid. However, the program has approved fewer claims in recent years, with the program only approving 2 of the 45 claims, or about 4%, that it received through fiscal years 2021 through 2024. It was noted in the report that it appears the program's relatively low participation rate and rate of approved claims is due to mine subsidence damage to eligible properties being relatively rare in Colorado. And we agree with that. When we go back and we look at some of the early studies that we commissioned, we found that a lot of their predictions have borne out. We're pretty much where folks thought we would be when we started this program, which is to say that thankfully in Colorado, we do have what can be considered relatively low risk for coal mine subsidence. But low risk, of course, doesn't equal no risk. We still have a risk. One of the largest factors in risk when considering coal mine subsidence is time. It's really the time from when that active mining ceased. And once we get past a period of about 40 years, the likelihood of those subsidence events occurring significantly starts to drop off. In Colorado, we're about 80 years past a lot of the mining that occurred in these areas. And so this does match with what we understand about the risks for these undermined areas. There are other factors at play, as Heidi mentioned. They did take a look at some of the other state programs and looked at some of the key differences there. A lot of these other states pay out far more claims than the division, but there are some key differences within these other states in terms of how they set up their insurance programs. Some of them actually insure areas over active coal mines. Mining out east, coal mining still is occurring pretty robustly today. And so they've had a shorter time frame from when some of those mines stop mining to where they're at today. So the risk does remain higher in some of those other states. Additionally, the other states have chosen to broaden their insurance programs by including commercial properties, by eliminating the eligibility date that we imposed at 1989. And so it's really open to anybody at any time. And so by virtue of those factors, they have just very different programs and abilities to operate those differently than we do. Moving on, as I noted, and as is shown within this report, our total costs have increased from approximately $114,000 in fiscal year 2021 to $324,000 in fiscal year 2024. It's a significant increase of about 183%, the majority of which has been due to increases in program spending on inspections. And so, as a reminder for the board, there's several different inspections that are conducted within the program. We have enrollment inspections. Those are done to assess and document the condition of the home at the time of enrollment. We would conduct initial claims inspections. So that would be when a claim is filed, we would assess the damage reported by a homeowner to determine the cause of that subsidence. And then the third category is additional claim inspections that might be conducted to more conclusively demonstrate the cause of the damage. And so the auditor highlighted that we have an opportunity to look at how we're conducting these inspections. Really, I think a lot of these costs have gone up in part based on the contractor that we are using to conduct those inspections. That contractor is Tetra Tech. Tetra Tech, I think, has worked well for us as a contractor. They certainly have a lot of knowledge and expertise in this area. But I think we have an opportunity to look at these individual inspections and really evaluate how much engineering expertise is needed at each stage along the way. There could be an opportunity, for example, on the enrollment inspections, to send somebody out there who doesn't necessarily have all of the engineering bona fides, but is otherwise qualified to go out and make visual observations. The enrollment inspections, there are aspects that could be technical, but largely the exercise could be handled by somebody with perhaps less expertise than the inspectors that are currently going out there. So that's something we intend to look at. We are sensitive to those rising costs. Part of setting up this program was ensuring that it's self-sustaining into the future. While the Office of the State Auditor found that we're not at any immediate risk of the fund running out of money. It is something that we'd have to really consider over the long term, because it would have an impact in the long term. And so we intend to take a close look at that. And some of the other key differences, again, if we look at other states, I mentioned a few of them. They don't have an eligibility date. They waive the inspections. They also, though, charge premiums for the life of the policy. As a reminder for the board, we pay, our participants pay $35 annual fee for the first 3 years of program participation. So in other states, these premiums are going to be significantly higher than the $35 that our participants need to pay to get enrolled into our program. So of course, I think, why do these problems matter? As the Office of the State Auditor rightly pointed out, a lot of these evaluations and assessments were done 30 to 40 years ago. So we've had a lot of time elapsed since then. We've got a lot of knowledge gained and experience in administering this program in that time. And I think, we are now at a time, based on the factors that were raised in this audit, to take a look at where we're at, to review the program structure, to look at lowering our fees, to look at opportunities to increase participation. And so that takes us to the 4 recommendations that we had for the second part of the report. The first is evaluating the current risk of mine subsidence in the state and the likelihood of qualifying claims being filed by participants. And so we have agreed to review the current state of practice necessary to develop up-to-date risk evaluations for homes both currently eligible as well as homes that are potentially eligible under expanded eligibility criteria. This is going to require outside expertise on this. And so we will be preparing a scope of work. We will present this proposal to the board for your approval for expenditures from the trust fund for this purpose. If approved by the board, we would then solicit the request for qualifications to perform this evaluation. And in doing this, this is going to answer a lot of questions for us. Are we still best served by maintaining a trust model, or would we better be served by looking at an insurance program? It's going to depend on where we shake out in terms of eligibility. We'll look at different eligibility cutoff dates. We'll also consider whether other structures should be included in this program, such as commercial structures. So there's a lot of different things that we can look at and opportunities in terms of reevaluating how we've structured this program. Our implementation date for that will be June 2026. With respect to the second recommendation, which was to review the program's use of contractors to conduct home inspections, that should include evaluating the potential to reduce costs by using contractors with less technical expertise to perform those enrollment inspections. We've agreed with this recommendation, and we will evaluate the potential for reducing costs by using contractors or staff with less technical expertise. And we will look at establishing appropriate guidance regarding the maximum expenditure amount for various inspection types. Any guidance setting on maximum expenditure amounts will be brought to the board for your approval. And the implementation date on that, this is one of our near-term goals, is set for December of 2025. With respect to Part C, the third part of this recommendation, this is sort of a cumulative recommendation set of series here, in that we will use the information that we collected in Part A and Part B to assess the overall structure, operation of the program, and consider changes to increase participation, maximize the benefits it provides relative to our administrative costs, and ensure its sustainability. This can include looking at providing coverage to private insurers, again, changing inspection requirements, and potentially making changes to our fee structures. So we'll use those evaluations on Part A and Part B to do that assessment. We'll look at, again, expanding eligibility for enrollment, assessing whether this should be provided through a private insurer, and evaluating current inspection requirements and fee structure to identify any updated changes. And we have set the implementation date on that for December 2026. The last part of this recommendation, under recommendation 2, part D, really just kind of wraps up the first 3 parts. Based on the information that we gather through parts A, B, and C, we will implement any necessary program changes and work with the board, the Department of Interior's Office of Surface Mining Reclamation and Enforcement, and the General Assembly to change program rules, grant requirements, and statutes as needed. And again, that's one of our longer term goals, with the implementation date being set for December 2026. I can say with certainty, we will need to revise our rules. At this time, we don't anticipate any statutory changes, but we'll see where we land at the end of these evaluations. And so, again, I will just stop right there and open it up for any discussion or questions from the board.
I have a couple of questions. One, did I hear that right, that a homeowner can enroll for $35?
Yeah, they pay $35 over 3 years, and then I think there's an additional $200 fee. But once you paid that, then you're enrolled into the program, and so it's a relatively low bar of entry for our participants.
Okay, the 200 adds up, but 35 seems like nothing. And then just outreach to homeowners. It seems like the easiest way to do that would be outreach to HOAs, because just getting a letter, nobody trusts what they get anymore. But we're, talking to neighbors, they trust a lot more.
No, that's great. That's a great comment. And we have done outreach specifically with homeowners associations, get a little more bang for our buck in terms of talking to them and disseminating that information. We've also targeted homes specifically that are not enrolled, that are out, but are eligible. So direct brochures, door hangers, mailings, things along those lines. We're also considering having some conversations specifically with some of the county planning offices in these counties that have coal mine subsidence potential, to talk to them and see about opportunities for also increasing awareness. And did you have another question, Ms. Stiegelmeier?
That was it.
So there's no active coal mining in, I guess my question is, the exposure is not increasing, right?
That is correct. And I think that is why we are seeing, relatively, we're not seeing an increase in enrollment, and we've been paying out fewer claims over the last several years.
Right. Very good. Any other questions for Mr. Cunningham? And thank you very much, the auditing staff. We really appreciate it. Always good to get feedback.
Yes, thank you, board. Appreciate your time. As you might have gathered, we're going to be having some more discussions with the board as we move forward on this. And so we hope to have another agenda item scheduled here in the next few months, where we can start talking specifically about some of these implementation dates, and we will go from there. So thank you.
Very good. Thank you, Mr. Cunningham. All right, on to item 7, discussion item. Is there Mr.
Yes,
Means?
sir. Yeah, yes, sir.
Perfect.
Well, Tammy's getting PowerPoint stuff set up with me here. This is Russ Means for the division. I have a couple of issues and stuff for that to bring to the board's attention. Today, we did the final revocation and stuff on a bond, and it brought to our attention and stuff some issues. So, as you know, staff has noted to the board on occasions in hearings that reclamation bonds have not been updated to meet the optimum time period set by policy. So in the situation before you today, this is a very old permit. The bond has not been updated since its approval back in the late 1980s, actually. And the reason for that is that being an older permit, the statute at the time it was approved actually had set amounts for the bond. It was $1,000 for an acre and $1,500 for 2 acres. A 110-1 limited impact is actually a 2-acre permit. So while it was inspected over several years and stuff as it was supposed to be, the bond was never updated because by statute, the bond was set at that amount, and there was no permit changes and stuff that would bring it up to current standards. So so it took a note in a 2002 inspection report for myself and staff. We had to dig and ferret to find out exactly what that was, because it just said by statute it said $1,500. And so, but we found it, and it's actually a 1993 statute. It's set up a little bit differently, formatting and stuff in there, but we were able to find that. So so there is sometimes some reasons why those aren't done in that. So but fortunately, there's only about 3 or 4 of these older permits that are left out there. But it did bring it gave us some education. So I wanted to pass that on to the board and stuff as well. But what it did is Director Cunningham and myself, we started to look at this and we reviewed our past due bond calculation backlog. And we want the board to know that you've expressed your concerns and stuff to us, and it's a concern for us as well. There are a variety of reasons why these haven't been done, and there are some that are delinquent, but the bottom line is that that number needs to be reduced. So based on the review, I've instructed staff from myself on down to make a point over the next 2 fiscal years and stuff to reduce that number significantly, so that we get all of our bonds back into our normal range within and that. So it takes some time. We have to go out and do inspections, and then we have to do the bond calculations, and of course get the bonds in place and stuff. But that's our objective. So this project is going to be on everyone's performance evaluations for accountability and for tracking. So seniors will be working with their teams to plot out a strategy to get these done, and to provide assistance to all the staff in that to achieve these goals. And I will periodically give you an update on our project as we move forward. But we wanted to let the board know on stuff that we've heard you, and we also have that same concern, and we're doing something and stuff in that to try to get those numbers and stuff down. So, and with that, if there's no questions on that, I'll go ahead and get into the second part of my presentation.
Questions?
Yeah. So the second thing today I'd like to talk to you about and stuff is our upcoming rulemaking that Director Cunningham has alluded to and stuff in his report. Before I get started on that, I'm proud to share with you the logo for our 50th anniversary coming up in 2026, July of 2026. You've heard us talk about it a little bit, but this is the design of stuff that we worked with a committee and stuff that came up with it. The importance of stuff there is in the upper left-hand corner is the Colorado insignia and stuff with 150 years. In the right-hand corner is the U.S. flag and stuff at 250. And then we have our own 50-year anniversary in the middle. So next year, all of us and stuff will be celebrating an anniversary. Colorado, 150th year as a state. The United States is 250-year anniversary, as well as our own anniversary for the when our act and rules and stuff came into effect and stuff that we work with. So today I'd like to talk to you a little bit about the rulemaking that is forthcoming, and the reasons why, and some of the things and stuff that we have the board will be participating in the future here. So rulemaking 101 is basically in that I'm going to talk a little bit about what's driving rulemaking for the 2026 year. The process that the DRMS has done in the past that has worked fairly well. And then talk about tentative schedules for informal stakeholder meetings, as well as the tentative schedule for the formal process. So what's driving rulemaking? Of course, Senate Bill 25054, the Legacy Mining and Modernization Act that was signed by Governor Polis on May 16th and goes into effect on August 14th of 2025. That's the primary reason for that. And we're taking this opportunity for a secondary issue and stuff of addressing some inconsistencies between hard rock and construction materials rules. So, how did that happen? Something went there. So, under the key components of SB 54, it creates the 110R reclamation only permit that you've heard about. It removes some antiquated financial warranty types. It disappeared.
That disappeared, Russ.
Okay. Where did it go?
Go ahead and share.
Stop sharing.
Yeah, stop.
Yeah. There we go.
Okay.
There we go. And here.
Here.
Okay.
Share.
Back.
Yep, and then go and start share. It won't be.
Okay, we're good. This didn't come back up though.
Yeah, go ahead and keep talking. I'll find it.
Okay, you find it and stuff and then go from there. So I'll just keep going and stuff there in that and we'll go from there. So oh, I can't talk, I can't see it.
Okay.
All right. Okay, that's cool. All right, so sorry about that. So Senate Bill 54, and that creates the 110R reclamation permit, which we worked with a lot of stakeholders and stuff in that to get done. It removes some antiquated financial warranty types. Specifically, we had some bonds and stuff that we looked at them, and in 40 some odd years, nobody had ever used them. In particular, it's like rolling stock and equipment and salvage credit, those kind of things. Nobody in either act had used any of that. And then also before you last year, we have a mine site and stuff that was using property and water rights as part of their reclamation bond, which is great for really big, huge corporations and stuff that have the manpower and the money and stuff to do that. But we had a lot of small operators thinking that was a great idea, and it's not because of the type of work and stuff that goes into that and the financial cost of putting that into place. So we're putting a threshold on that and stuff. They have to have a really, really large bond in order to take a look at that as an option and stuff there. And then inconsistencies between the rules. Past few rulemakings have been specific to hard rock or construction materials. And what this has done is it's created some inconsistencies in definitions and process. So with both sets of rules open, our goal and stuff is to address those inconsistencies and stuff so that they're more in line and consistent. So that it's better for staff, it's better for the board, as well as general public and operators and stuff, so that there's not so much and stuff. Oh yeah, you have to remember it's hard rock or construction materials and stuff. There are some differences and stuff that can't be changed just simply because of the way the statutes are and what they deal with. So, and then also part of that in 2018, 2019 rulemaking, in that we did a lot of work and stuff to update our forms of communications and stuff with e-permitting and electronic submittals and that. And so we'll be making sure that both sets of rules and stuff reflect that. So most recent rulemakings have involved a two-part process. The first part is an informal process, and then the second is obviously the formal process. The informal process involves the division and stuff meeting with groups, as well as individual stakeholders and stuff in meetings and stuff to review proposed rule changes and have discussions and stuff of the basis and purpose and stuff for those changes. And also to solicit comments and suggestions and stuff in that on those rules in an informal setting so that we can have a better discussion. So, and the formal process, that's more dictated by statute, and that has required deadlines and other processes and stuff in that, which I'll talk about a little bit more. So the informal process, we have a tentative schedule for the informal stakeholders, and it's posted on the website. And we also did an email blast to all of our operators, and also sent out specific invitations and stuff to potential parties, such as some of the environmental groups, some of our industrial groups and stuff, and that have been parties in the past. We wanted to make sure and stuff that they got notice and stuff up front. We say tentative because if there's more meetings that need to be done, then we'll schedule those. And on the flip side, if by chance the stuff there's less discussion and stuff that needs to be done in the informal process, maybe we can move up our schedule and stuff for the formal process. The goal here is to gain agreement and consensus wherever we can amongst the various stakeholders before entering into the formal process. And this also helps in stuff identify any contentious issues so that we're maximizing the board and the parties' time in that formal process. So the goal, when we're done with the formal process and stuff, is to have a final draft that's ready for presentation to the board for their consideration for promulgation. So the tentative informal schedule, which is on the website in that, but I'll share it here and stuff, is next week we're going to have an all stakeholders kickoff meeting on Wednesday, June 25th. And then from there, we're going to bifurcate and we're going to have meetings and stuff with construction materials folks, and we'll have meetings and stuff with Hard Rock stakeholders so that they can focus the stuff on theirs. They don't have the construction materials stakeholders don't want to hear a lot about the 110R permit because it has nothing to do with them. Vice versa, there may be some issues and stuff that go either way, but that way we're maximizing everybody's time and stuff within these individual stakeholder meetings and stuff in that. And so once a month between now and October, on the fourth Wednesday, we'll be having these meetings. They're an hour and a half long. And we'll start off by focusing on just on a couple of rules at a time, taking these in bite-sized pieces and stuff instead of trying to take on the entire rules and stuff in one fell swoop and jumping back and forth and trying to maintain and stuff some kind of an idea and stuff with the flow and stuff of what we're working on there. But the final, our final objective and stuff of that is in October 22nd. We'll have a meeting, and then we'll have that final draft and stuff hopefully out fairly soon thereafter. So if we get the final draft and stuff done by October, then our goal and stuff in that is to move into the formal process. We'll have a final draft and stuff by December to share with the board. But also that will allow us to start the Secretary of State process. We have to issue the proposed rules. We have to have a statement of purpose and basis for why we are changing the rules. And then those have to be submitted to the Secretary of State, and they're published in the Colorado Register. Colorado Register only publishes twice a month or whatever, so we have to take a look at timing there. And the most important thing is rulemaking hearings cannot occur earlier than 20 days after the publication. So if we get things done in December, we could actually start having meetings and stuff in January, February, and I'll get to that in just a minute. So, and at that hearing, the board goes over all the rules and we talk about it and do red lines. The board can accept the rules as they're submitted to you. They also can propose changes based on testimony from all the formal stakeholders and stuff and address the concerns there. They take a final vote, and that's the promulgation of the rules. Once that's done, then we have to publish in the Secretary of State within 20 days of adoption. So 20 days after the board hearing, And then the AGA files a rule opinion. It goes and stuff, it has a review and stuff by a board and stuff that takes a look to make sure that the rules that we have proposed and stuff don't conflict with statute or anything, or the intent and stuff that's there. And over the last 4 or 5, I think we've had 1 or 2 items that have popped back up and stuff that we've had to explain and stuff in a little bit more detail, but we've never had one flagged and stuff that was totally against that. So our tentative formal rulemaking process, just so everybody knows, is we're hoping and stuff in January and February to have formal stakeholder meetings and stuff with our stakeholders. And then what we're going to try what we want to do and stuff is have rulemaking where we have 1 hearing and stuff for construction materials, and then we'll have another hearing and stuff the next month and stuff on Hard Rock. That way you're not in 2 or 3 days of hearings on rules and stuff. It's going to be tough enough on just one set, but we think that by keeping them separate and stuff for that, the board and stuff for that will it'll maximize your time and stuff to the best we can. So with that, if there's any questions, there's any comments or any suggestions and stuff in that, we're open to hearing them. There will be red line versions and stuff on the web, and we'll also be sending red line versions of the rules and stuff to our different stakeholders and stuff so that they can start reviewing them for future discussion. It's up to Chuck and stuff, but you guys could take a look at those. And if you have any questions, concerns, or want some additional details on any particular part of that, like I said, right now it's in the informal process. So what comes out at the end and stuff could be quite different than what we're proposing. But take a look at that and reach out to me and stuff if you have any questions or stuff on that individually. I'd be more than happy to discuss that. So with that, if there's no other questions or anything, then I will stop sharing my screen and ask for any questions.
Any questions from the board? I just actually have one, Russ. So when you're saying stakeholders, does that includes operators, that includes other agency, who all is in that, and how do they get notified or whatever of the meeting?
Yeah, everybody, all the operators and stuff got an email. Everybody that's in our permit system that has an active permit and that got an email notice and stuff that basically has this information and stuff there on the meetings and the kickoff and stuff. So stakeholders and stuff could be anybody with interest and stuff. Certainly operators, industrial industry groups, environmental groups, you name it and stuff. It's a public process. Individuals and stuff on their own and stuff can actually be a stakeholder. And in the informal process, they can come in and out and wherever they want to or whatever. But when we hit that formal process, that's where things and stuff are submitted and stuff in a legal format and stuff where Jeff takes over a lot of that, Jeff Fugate and stuff. But we have, submittals, discussions, and before the board and stuff for that, we'll have the pros and cons and stuff of any kind of additions or issues and stuff that the board needs to consider.
Got it. Very good. Well, thank you very much, sir.
Yeah, and it's all on, we made sure that it's all on the website. So if you go right to the website on the very front page and stuff, there's all the latest and greatest. So the schedule's there, and that's where we'll post the red lines of the bulk construction materials and Hard Rock rules that we're proposing. And then also we'll when we get to that point and stuff, that's where our basis and purpose will be in that, so that everybody knows that's the place to go.
Very good. Very good. Excellent. All right. I can't see the room, but I'm assuming there's no public in the room. Is there any public online for public comment number 8? Cammie?
Nope. Nobody online.
Nobody online, nobody in the room. Okay. And then no reason for executive session, Chuck?
Correct. Yeah, no reason this month.
Very good. All right. Well, with that, I guess motion to adjourn. Does anybody have a motion to adjourn?
So moved.
Ms. Stiegelmeyer, Mr. Baker there to second.
I'll second it.
And let's vote to adjourn. Everybody in favor, say aye.
Aye.
Aye. Anybody against adjourning? I don't think so. All right. Thank you all very much. You guys.